Good afternoon, almost. Looks like we are letting attendees in. We'll get started here in just a moment. Right. It looks like we're close enough to 12 for me to go ahead and start my introduction. My name is Patricia Reedy. I'm with Partners Resource Network. Partners Resource Network operates the network of parent training and information centers for the state of Texas. We're grant funded under the U.S. Department of Education Office of Special Education Programs, or OSEP. Because we are grant funded, all the services that we offer are free. We support parents and professional children with disabilities age 0 to 26, and we work with that youth self-advocacy age that 14 to 26. We provide education opportunities, conferences, one-on-one direct support, referral, and information for any and all people who contact us, and we do that free of charge. Because we do not charge and we're grant funded, at the end of this presentation, there will be a quick survey. If you could take just a few minutes to answer that for us, that's one of the ways that we keep track of how we're servicing our parents, and we do send those back. All right, and at this time, I'm going to turn this over to Allison with Consolidated Planning Group and let her introduce everybody.
Thanks, Patricia. Certainly a pleasure to be back with you today. Allison Scoberg here, Consolidated Planning Group. So I always like to cover a couple of housekeeping items. Today we are in webinar mode, which means we can't see you or hear you, but we do know you're there. And we are glad you're here with us today. Today's webinar is being recorded, and everybody who has registered for this is going to get a copy of today's slides, so you don't have to take notes of every single thing you hear, because you are going to get a copy of the slides. Consolidated Planning Group is a holistic special needs financial planning firm. We are an advisory and consulting firm with over 30 years of experience, and we partner with families just like yours in navigating planning for the future of your loved one with special needs, planning for the future of one day when you're not here anymore. We do a lot of advocacy by way of webinar and educational webinars, and kind of giving you the tools and resources that you need to make good decisions as it relates to planning for your loved one. We help put lifetime protection plans in place, lifetime care, transition planning. We help people open ABLE accounts. We're nationally certified as Social Security advisors and members of the Special Needs Planning Academy. And, you know, I always pause here to kind of talk about the differences of what we do at CPG and what Boyd Handley does at the Handley Law Office. A lot of times when it comes to special needs planning, Boyd probably gets calls on the financial side of things for doing things of what we do, and we get calls all the time for what Boyd does, guardianship, wills, special needs trust, your legal documents. That's going to be your legal team. But we're on the financial side. I always say that Boyd's the paper and we're the money, okay? So those legal documents are so super important. We're going to touch on those today. Our primary focus today is surrounding guardianship and alternatives to guardianship. But all of those legal documents, they're very, very important. But when it comes to those special needs trusts, the funding and how we fund them, where the money comes from, how we leave access to the money while we're alive for our own retirement and needs and funding for the future, that's really where we come into play. So we are excited to be partnering again with Boyd Handley and the Handley Law Office. It's certainly been my pleasure to partner with him over the years, and like me, he eats, sleeps, and breathes this both personally and professionally. He himself has a daughter with special needs, and I have 2 kids with special needs. So we get it. And so these webinars are born honestly out of some of our own frustrations and how difficult it is to navigate these things and what to know, what to ask. So we invite you today to put your questions in the chat box. While Boyd is talking, I'm going to be monitoring the chat box, and we're going to answer just as many questions as we can. And as if you're keeping time or you're on your lunch hour, we're going from 12 to 1 today, so we will be done by that time. So having said that, Boyd, welcome. Thanks for joining us today, and I'm going to turn everything over to you.
Okay, thanks, Allison. Appreciate inviting me here today. Next slide, please. I just want to tell you a little bit about myself. I've started my law firm in 2015. As Allison mentioned, I do have a daughter with special needs. I have my wife and I have full guardianship of her. She's 29, so 11 years ago, we were sitting in front of the court getting guardianship of her. Of course, she's improved tremendously. Most of my cases nowadays are partial guardianships, and I think that if we had to go get guardianship from my daughter today, we'd probably have a partial, because as she has grown older, she's really improved in a lot of her skills. We also do probate, as Allison said, wills, special needs trust, and elder law, and help families with SSI and Medicaid. Next. One thing I will say that this presentation does not create a client relationship, and I will say that this is general information. And in most cases, you need to talk to your lawyer or call me up, because each situation is very unique. And so please take all this information as general information, and depending on what your particular situation is. Next slide.
And, Boyd, one of the things I like to mention, if you guys have attended our webinars in the past, I always like to mention that your situation is specialized. When you have a loved one with a disability, your situation is very unique. It is very specialized. It's very important that you have money in the right buckets, and that the attorney that you are working with, or the professional that you're working with, is nuanced in special needs. So there are a lot of financial advisors out there, and very few of them, about 125 total in the U.S., are nuanced in special needs. And when it comes to attorneys, you really want to work with an attorney that is nuanced in special needs. And I always say, this is not your brother, the real estate attorney, or your neighbor next door that said that they do it for free and they're a contract attorney or things like that. You really want to work with somebody nuanced in this, because we see a lot of documents over the years. We've seen a lot of documents that were created that needed to be redone, because there were some critical mistakes in there as it relates to special needs planning. So I think that's very important.
Very good. A lot of times I talk about the special needs toolkit. That's everything you should think about with your child with special needs. This is basically what we've done with my daughter. But today we're going to be talking about the left-hand side of the chart, guardianships and alternatives to guardianship. Next slide. Why do you need guardianship in Texas? Well, unfortunately, when our kids turn 18, they're adults in the eyes of the law. So what we were doing right before they turned 18, we cannot do now that they turned 18, unless we have a power of attorney or medical power of attorney. And if they're not able to sign those documents, then guardianship is needed. Next slide. Normally when we won't go through all of this, but and a lot of this information, I like to tell stories. So when you get a copy of the presentation, you can really look at it in detail. But when someone comes in my office, I use this American Bar Association checklist in my head anyway. And it helps me to determine on whether guardianship is needed, whether a full guardianship is needed or a partial, or whether the parents can get by with a power of attorney or medical power of attorney. Or we'll talk a little bit about supported decision-making agreements, which are kind of a gray area that's in between guardianship and the power and medical power of attorney. Next slide. Guardianship made some major changes in 2015. It required attorneys to go over the alternatives to guardianship with their clients. And we do that anyway, but now we're required to. And if I've got any clients that are over the age of 18, and I have quite a few, I even have elderly clients that come in, their children come in and ask for guardianship of their parents when they don't have a power of attorney, a medical power of attorney. But what we do now is that we have to quiz on whether alternatives will work for you or whether guardianship is work. And especially when the child is over that age of 18, we really have to go into detail with the courts. The supported decision-making agreement, which approved in 2015, we'll talk about that. It's used in specific situations, and unfortunately, the title of it's maybe misleading to a lot of parents. Next slide.
Boyd, a lot of families, this is a big decision, as you well know, you went through it. And a lot of families, quite honestly, they don't know what they need. And I really always encourage families to know that when you go and meet with an attorney for the first time, you don't have to know what you need, because like he said in this here, they're going to be talking to you about the limitations. What is the functionality of your child? What are they capable of? What are they not capable of? And together, you guys are going to come up with what the best option is, the least restrictive option for your loved one. So I always just want to encourage people here that you don't have to know everything when you go to the table and you're just sitting down to kind of just explore information. People like Boyd are there to help you understand what those options are, so that way you can make a really good informed decision.
Yeah, I've got a good comment on that. When we went 11 years ago to court to get guardianship of my daughter, we knew it was coming, but it was like a baseball bat hit us in the head when we were there. We were in Harris County at the time. We live in Fort Bend now, but 11 years ago, every hearing was in person. Now, Harris County does hearings by Zoom, as long as they're non-contested. In Fort Bend, it's about half and half. But I will say that when we went into the hearing, my daughter was there. A lot of times they do not have to be there if they're in school, but we were talking to the judge, and the judge was looking at her and kind of wondering, why are you here with us? And so our attorney ad litem, who's a very good friend and mentor of me now, told the judge to start asking my daughter some questions. And after about 3 or 4 questions, the judge, it's almost like a light bulb went on, and she realized that, yes, my daughter needed guardianship. But, sometimes our kids look like they need guardianship, and sometimes they don't. And it's really, guardianship is used to protect them in the everyday society, because once they turn 18, they can be taken advantage of like an elderly person. Someone can come up to them and have them sign a contract. They can run off with someone. Maybe they're are not mature enough to understand that. With my daughter, she thinks everyone's nice. We also, so she really needs someone to look after her, to let her know, do you open the door for someone or not? So guardianship in a lot of situations is needed. And I tell parents it's to protect our loved ones. So not as much as taking away the rights, which is hard to do, but really to protect them. And guardianship is not permanent. You can always go back to court once these kids mature up and give guardianship back to them. So just keep that in mind. In Texas, there's guardianship of the person in the state. Most of the time I do guardianship of the person when these kids are turning 18. Usually guardianship of the state is with an elderly person. Now, what I normally do with parents is when they come in is, does your child have any accounts in their social security number? Do they have an underage minor account? And or have you set up a fidelity, for lack of a better word, account for them? And I usually tell them, let's cash those out, because what you don't want to do is do guardianship of the estate of someone turning 18, because you have financial reports that you have to file each year. In some situations, you have to get court approval to spend money, and you have to hire an attorney to file the financial reports, where the normal reports, annual reports for guardianship, a parent can do. So those are the situations there. Mhm.
Boyd, from time to time, we've seen things where like maybe families haven't done guardianship. And I always like to say it's okay. If the child's 19 or 20, just because you didn't do it at 18 doesn't mean that you can't go back and do it. But before we kind of go down too many rabbit holes, I would like you to talk about the problem. So whether you're pro guardianship or against guardianship, it's a matter of what's in the best interest of the individual, right? That's the first part. But there is a such thing as where we've seen where families have had their loved one with a disability sign a power of attorney and a healthcare power of attorney, because our kids will sign what we put in front of them. They're willing to do that. But there's an issue, we've seen this come up where maybe the child was hospitalized or something along those lines, and the hospital didn't recognize it because they said that the individual did not have the capacity to understand what they're signing. So could you explain that kind of scenario to us a little bit?
Yeah, I've got quite a few, parents that I'm doing a guardianship now for a 40-year-old young lady or older person. So, it really doesn't matter if you've waited, if you haven't gotten guardianship and your child needs it after the age of 18, that's okay. But some of the horror stories that I can talk about is that I've had a parent that had adopted a child from the Eastern Bloc countries, and the young lady had fetal alcohol syndrome. And what that is, during gestation, the mother was drinking, and actually part of the brain is missing at birth. And these individuals have a really high tendency, anger issues. So, and they may be highly functioning and with a high IQ. But what happens, the power of attorney, medical power of attorney, you have to have the cognitive ability to understand what you're signing from a legal and financial standpoint. And so these kids with fetal alcohol syndrome will sign those for their parents, because the parents say they don't need even partial guardianship. But what happens if the young man or young lady wakes up one morning and their anger issues are coming out, as they do quite often, and they say, mad at mom and dad? If they tell the right person, then that power of attorney and medical power of attorney goes away. So you just have to be cognitive of that issue, even if your loved one has high IQ and high functioning. The other situation we had a number of years ago, which is, I think Allison has heard me say this many times, that we had a young lady who was fairly high functioning, didn't have partial guardianship, and she was going in for a non-emergency operation. I believe it was her tonsils. They got all the way through. They were rolling her into the operating room, and she said no. So the doctor said, we can't operate on you. Now the hospitals will operate on you in an emergency to save your life. But if you've got a loved one that's maybe on the borderline between partial guardianship and maybe power of attorney, medical power of attorney, just be aware that if you don't have guardianship, then if they have to have a non-emergency operation and say no, then you're out of luck. You can't do anything about it. Okay, we talked about this quite often, full versus partial. I won't go into this, but full takes away all the rights below plus a few more. Those are what I call the hard rights that are taken over. I've got a number of clients that we've put in, if the young person is able to get a driver's license in the future, he or she is allowed to. We even had one where the young man loved to go hunting and fishing with his father. So what we put in there, instead of taking away all his rights on farms, we were able to say that he can still get a hunting and fishing license, but he cannot purchase a firearm. He cannot purchase ammunition. His father or whoever he goes with can do that. So we can actually tune the guardianships to really what you want when we're looking at a loved one. Next slide.
Boyd, can we talk just a minute about, like the housing and stuff like that, and what guardianship means and it doesn't mean,
Yeah.
like when they're an adult and they decide they're leaving home or some of those things. Can we talk about that? Because I know that comes up from time to time as an issue.
Absolutely. Normally what I tell parents, and I actually tell them they need to do this, is take away the right of the domicile, to choose their domicile. Because what that does is that if your loved one, well, your loved one, even though you have guardianship, they have their rights, and they can run off with someone and do a few other things, which we won't mention here on the presentation. But if you take away their right to decide their domicile, what that gives you is that if they run off with someone and they're in danger to themselves or whoever they ran off with, that will allow you to get a constable to go pick them up. So that is very important with some of these kids who may be persuaded by someone else. So I always tell parents is, even if in a partial guardianship, let's take away the right to choose their domicile.
Thank you.
Next slide. Okay, guardianship steps. We can file guardianship 180 days prior to the 18th birthday. Always like to do that. That way we can get everything in and get the attorney ad litem, who is the attorney appointed by the court to represent your child at the hearing, and get everything done and get a hearing date scheduled. As we get into the November and the December holidays, it's extremely difficult to get a hearing date. Usually it takes me about 2.5 months. So what I always like to do is get everything in, and that way we and the parents and the attorneys are waiting until the child turns 18 to have the hearing date. The physician certificate, which we'll go over quite in detail, it has to be filled out by an MD. That can be your physician or a psychiatrist. And basically what that does is tells the court how the disability affects everyday life. And that can be done within 120 days of filing. We've had situations where it was done a year ago, but the physician signed it within 120 days, but the evaluation has to be within 120 days. Once we file the certificate, the application with the court, your loved one will be served by a constable, the citation. I know that when my daughter Caitlin was served, she loved it, constable coming to the front door. But I always like to tell parents is that, if you're going to have a constable car out in front of your house, you're going to have to tell your neighbors what's going on. So it's better to know ahead of time that they're going to be showing up. Unfortunately, Montgomery County is the only county that will call and make an appointment. All the other surrounding counties will show up on your doorstep. And if you're not home, they'll leave a business card, and then you can make an appointment. So why they do that step in Harris, Fort Bend, and surrounding counties, I don't know, but I guess that's just part of it. You're going to take a training course, about a 30-minute training course, and file a certificate with the court. As I mentioned, the court will appoint an attorney ad litem to represent your loved one. That attorney will come out to your home in person or by Zoom. It's about half and half now, and talk to you and the co-guardian and your loved one. If you're in Harris County and Montgomery County, they're what we call statutory probate courts, and the judge will appoint an investigator to come out and meet with you. In Harris County, those are being done by Zoom. In Montgomery, it's half and half. And also in Montgomery County, you've got an extensive, I think it's like a 12-page questionnaire that you'll have to fill out. So very different in the counties that you deal with. If you've got older siblings, then I will be sending them a waiver. If you're divorced and not having the biological parent as a co-guardian, then we have to serve them with a citation if they won't sign a waiver. And I will mention here that the only time that you can have co-guardians is with the biological parent or with a biological parent and step parent if the living biological parent agrees with the step parent being co-guardian, or if one of the biological parents is deceased. Once the parents are both deceased, then you may have a sibling or an aunt and uncle as the guardian. You cannot have any more co-guardians. I'm actually doing a guardianship with someone at Brookwood now, so we have to serve the administrator at Brookwood a waiver notice noting that one of their people that live there will be going through guardianship.
Boyd, the first question, I have two questions for this slide. Some people have MIA other parent, like we don't know where they are, or maybe they're out of the country. So can you just mention that, like how that works if we don't know where the other parent is?
Yeah, that's very easy, actually. We have the parent served at their last known address, even though we know they're not there anymore by a constable. And once they're served, then we just have that service filed with the court and we go about our way. I have had one client that lived overseas, and so it took a while to first figure out how to get that person served in the country that they lived in. But once we did that and got the application back saying they were served, then we can go ahead into the hearing. So really, without if there's a missing parent, then that's actually probably easier than trying to, get one of the other parents that where they are. Okay.
And then you mentioned on these physician certificates, and I'm just going to reiterate: psychiatrist, psychologist, your regular primary care physician, pediatrician, licensed clinical social worker doesn't count. Some of these people don't count. But I guess what my question is so in general, most people are going to take that physician certificate to the doctor that has the most history. So sometimes when we have kids with disabilities, that doctor that has the most history is not the primary care physician. It might be the neurologist or cardiologist or oncologist. It could be any of the specialties. But we've seen before where the physician is unwilling to sign off on this. This might be a case where somebody has a kid with ADHD or high functioning autism and things like that. And so in the example that it's really felt strongly that the individual needs guardianship and that the physician they thought were going to sign off on it doesn't. Do you have recommendations for them on that?
Yeah, I forgot I had a lot of clients that have moved here from other states and they've been here maybe less than a year with a child that's turning 18. So I've actually got a list of all the physicians and a combination of psychiatrists and physicians that have signed previous physician certificates for me. So I actually will send that out to a parent that maybe hasn't established a doctor yet in the area here. The other situation is that when there's intellectual disability, usually it's a psychiatrist, not a psychiatrist, but a psychologist that has done the evaluation. And actually, we have on page 3 of the physician certificate where the MD can say he's using another person's report as long as that report's been done in the last 2 years for intellectual disability. So it allows them to read the report, put the score down, and then keeps them from having any liability for using someone else's report. So that helps quite a bit.
We have a good comment I'd like to bring up, and then we'll go on to the next slide. She says she's a SPED teacher, and one of the one reasons the parent they don't get the guardianship is for financial reasons, and that they have to renew this annually. Are there agencies and resources for the indigent, basically, that would help families out financially for this? And what about families that are non-English speaking?
Yeah, we'll start the first question first. In Harris County, there's the Houston Law Association that has, or Harris County, that has pro bono people that will do work, disability rights. Also, if you qualify, they will help you with that. So Harris County, we have those two ones. In Fort Bend County, we have the Brazos Bend Guardianship Services. If you meet a certain criteria, they will actually pay the attorney to do your work, and then we can actually file the indigent application with the court, and the court will pick up. And this happens in Harris County. You can do that in Harris County. They'll pay all the fees, the bond, and everything else. So those are the two ways in Harris and Fort Bend County that you can get your guardianship done for little or no money. Unfortunately, I'm not that familiar with the other surrounding counties that have that, but in most counties, I would say have the individuals call the local bar association, and a lot of times they do have, even in Waller, Montgomery, they have attorneys that will do it pro bono. Mm-hmm.
Someone said legal aid is another good resource. I agree with that. They do have several offices in Texas. And if you say if you like Google something like guardianship for low income, those legal aid associations, whatever their names are, will usually come up, and they have several each county. And then I always like to mention here that if you are in Galveston County, if you happen to be in Galveston County, guardianship is free in Galveston County. They have a big grant, a big endowment or something, and so guardianship is free in Galveston County, but you can't just go there and get it. You actually have to be a resident of Galveston County for that. So I just wanted to mention that in case we had anybody out there for that. And then it just lends itself to another thing, and because I wear the financial hat, Boyd, I always like people to plan financially. So could you just give them a range? I'm not asking for your prices, but could you give them a range for a family that's trying to plan and set money aside for guardianship, what they could expect to spend on a guardianship that's not contested?
Yeah, you're probably looking at about, with all the fees and stuff, about $3,700-3,800 at the end. And then depending on the law firms, I've seen up to $6,000 at the high end. What you're going to end up paying, you're going to pay the attorney fee itself. You've got filing fees. You've got the attorney ad litem fee to be paid. That really varies quite a bit. In Fort Bend County, there's two courts that actually pay that for you. In Harris County, it's capped at $700. Normally, I only charge $450 for that because I'm not trying to make any money off an attorney ad litem, but they can run between $450 and $700 in Harris County. In Montgomery County, you actually pay a upfront fee. I believe it's $450, and that normally stays within that range. So, and then you'll have a bond that can run between $125 per either person or by co-guardian, and then the guardianship letters are $2 a piece. So that's the cost of that. Each year you have to file an annual report that runs between $12 and $10 to file that each year. And then, ever how many guardianship letters you want at $2 a piece. So I normally tell clients to get 5 of those with that. Okay. Who can be qualified for a guardian? Really almost everything, anybody. They have to be over the age of 18. that can't have a criminal record. I will say that if you've had a criminal record 20 years ago, we can probably get you as a guardian. We just have to tell the court what's going on and why you did it, and hope, maybe have some letters of recommendation. I will tell you that I was the attorney ad litem in a hearing a couple of years ago, and the father did not tell his attorney that he had a DWI 2 years prior. So we got in there, and usually it's really better to tell the judge that something's going on, because you don't want to get embarrassed like this man was at the hearing and it's on tape. But the judge asked you, he said, Mr. So-and-so, 2 years ago, you had a DWI. Is that correct? He said, yes. Well, he said, Mr. So-and-so, well, unfortunately, I'm not going to let you be a guardian of your son. Your wife can be guardian. Come back in 3 or 4 years, 3 or 4, and I will consider. And he didn't say I will give you co-guardianship. He said I will reconsider if you've been clean since then. So I was extremely impressed. Well, all the probate judges that I've been in and all the surrounding counties really look after the best interest of the child or adult. And this is a great example where the judge did not let the father be a co-guardian due to his DWI. So I always tell parents is that I really hate asking them up front, but I always ask for up front if you have any criminal records or any DWIs, because it's extremely important to know ahead of time. Because when I registered the parents with the JBCC, which is the judicial branch that oversees guardianships in Austin, along with taking the course that you have to take, they'll do a criminal background check. So the judges are going to get the information. It's better to let your attorney know ahead of time, where we can start working the letters and at least have an explanation for the judge at the hearing if we have to wait that soon.
Boyd, some grandparents have custody. They've raised their grandkids. Is there, and I'm just asking for age. We understand if an elderly person doesn't have capacity to be a guardian, that's not going to be granted. But there's no magic age. Like if somebody was 75 or 80 years old and of sound mind, they could be a guardian of their grandchild if that was the situation. Is that correct?
I mean, that's right. As long as you're in good shape and can actually take care of them, that's no problem. I've had a few cases where the parents are getting up in their late 80s and 90s, and they have a child at guardianship. And I've had one where they've turned that child over to the Harris guardianship group because no family members wanted to take care of their 55-year-old son. And then, I've had situations where the mother has turned over guardianship of her daughter to one of the siblings because she was getting up in age. But, as long as the individual is competent and good health, then that won't be a problem at all.
So usually we make the recommendation that you have a named successor guardian in the event that you become incapacitated or pass away. Yep. But there are situations. I mean, we meet with people all the time to say, it's me. This is it. There is nobody else. And so for the families that might be on here today, that this is it, there is nobody else, they worry about that. That's a big deal. Yep. So in those situations, do you have recommendations of what they do in those situations when there is nobody else?
Yeah, there's private guardians that are registered and bonded that you can talk to ahead of time and put their names down. There's the Harris County Guardianship Services that take over when someone dies without naming someone. The Brazos Bend guardianship, they do private and also guardianships for people. So, there are situations where there are, people out there that can look after your loved one. Now, what we do with the current guardians, we have a successor named in our wills. If you don't have a will, there's another document that you can do that names your successor guardians. And just say in my situation, if my wife died in an accident, then my son or my mother-in-law would take our wills that names them as successor guardians, and then go to court and go through the guardianship process for my daughter Caitlin. So that's how it works. I've probably done 4 of those, and in my career, and it works very well. We take the will and the death certificate and file the application with the probate court.
But the bottom line is all is not lost. If you are the end of the line and there is nobody else, all is not lost. You don't have to despair. There are options out there for even people that don't have somebody specifically that they can name. So that's good
correct.
to know.
And also, if your guardian lives out of the country, what we can do is do a temporary guardianship with a family friend until that individual can get their visa and come into the country and go through the guardianship process. Okay. This is the physician certificate. It's small, so you won't see what's going on, but it basically tells the court how your child's disability affects their gainful everyday life. Next slide.
Where can they download this certificate? So this certificate is the one that is going to need to be signed off on by a physician. Where could they get this to download this?
You can get it on the probate website. What I do with my clients, even before they become my clients, I send them a very detailed email that shows all the steps and what they should do and understand. I also put, depending on what county they're in, a copy of the physician certificate that they need to fill out along with a very detailed questionnaire. But if you want to go to the county probate website, you can play around and get into one of the courts, and they usually have documents there, and you can download. One of the things that I do with clients is sometimes, as you mentioned before, they're on the borderline. Do I need guardianship or do I not? I actually tell the parents, go in and especially fill out the second page here, which is the page on the right, and it basically goes over what your child can or cannot do. And if you've got any no's, then a partial guardianship is probably needed. If you've got everything yes, they can do that, then let's go with medical power of attorney and power of attorney on that. Okay.
Okay, thank you for that, Boyd.
Next slide. Okay, we're going a little bit into the physician certificate on the first page. This happens all the time, so I try to tell parents that be sure your MD fills out everything. But the main thing on the first page is that when your physician is giving your child an evaluation, and I'm looking at the clock, so I'm going to speed up a little bit, is tell your child that this evaluation will not be privileged. They may not know anything about what the doctor is doing, but your doctor should tell them back, because some of the courts will not take this. It's like the Miranda rights with a criminal. You've got to let them know what's going on. Next slide. This is page 2, and this is some of the things that you can check off to see what your child can or cannot do. I won't go through all this, but vote in a public election, make complex business and managerial. We do have 2 things here that attend to basic activities of daily living, which is bathing, grooming, dressing, walking, toileting. If they're checked yes or no, or even yes, then we can still get full guardianship if everything else is checked no, because this is the only 2 deals that can be checked yes and still get full guardianship. But if you've got intellectual disability as one of your disabilities, then they should check yes here. And then on the next page, next slide. This is on page 3 or 4, and that box is the determination of intellectual disability. I mentioned previously that if you're a physician is filling this out. In most cases, they don't do an intellectual disability analysis, and they can actually check here that I'm updating or endorsing and writing a previous report, but that report has to be within 2 years. And then, of course, by using that report, then they will mark down the total score of the IQ test. Once we get down to severe and profound, there's no doubt full guardianship is needed. Now, when you're in mild and moderate, probably a partial is what you end up doing. But if you're in those low numbers, then there's no doubt full guardianship is needed.
Okay, so one of the things I just wanted to mention on some of the testing that you're talking about, sometimes you guys may have had IQ testing done through the school, through the ARD process, your IEPs. You may have testing that has been done that way. A lot of families are connected with their kids with disabilities, are connected to the Texas Workforce Commission, VR, vocational rehab. They typically do testing. So there may be some testing that you have already had done that you can submit to that physician and they can use that. And I just like to mention that here because that testing's pretty expensive. It could be $2,500 to $5,000 out of pocket, depending on what the diagnosis is. It's going to depend on whether or not your health insurance is going to cover it, but it usually doesn't. So you may have had that done. So go digging. If you don't know if you have it or not, go digging because you might just have it. Okay.
Yeah, and I will say that you may be able to get your physician to do a mini exam on your loved one and then possibly look at a IQ evaluation that may be more than 2 years old. So really talk to your physician and see what he or she is comfortable in doing. I mentioned before.
I was going to say a letter with outdated testing. We've seen a letter with outdated testing. So the doctor basically saying, listen, I've been seeing this kid for 15 years. The condition hasn't changed, although the testing is outdated. These are the limitations. And I've actually seen those types of things accepted before. Someone said, you mentioned a POA and similar being signed before guardianship is completed, but is it valid if they don't fully understand is the question.
No, it's not. I have only done 3 or 4 power of attorneys and medical power of attorneys, POA power of attorney and MPOA medical power of attorney for kids that are turned 18. And the only way that I'm going to do this is have the young person in my office in a separate conference room. Their parents will be in another conference room, and I'll actually quiz them. Of course, they might have been coached by their parents, which is fine, but I will quiz them to be sure they're understanding what they're signing. Otherwise, I'm not going to do it. And then, if a parent comes to me and says that my child needs guardianship, we may get through it, even get a physician's certificate. And then they say, well, we're not going to do it, but we want you to draft up a power of attorney. I'm not going to do that. Because I, as a attorney, have seen documentation saying that they're not have the cognitive ability to do that. So I'm not going to do that, even from a personal and any ethical standpoint. So just be careful that if you're going forward with a guardianship and decide that at the end of the day you don't want it, then it's going to be very difficult unless the attorney doesn't know about your history to get a power of attorney and medical power of attorney on that. Now, I will say that the physician certificate has to be signed by MD. Now, there is one situation where a psychologist can sign the physician certificate. I've only had this come up once in my career. It was in Fort Bend County, and the psychologist was from Texana, and he signed the physician certificate, but the only disability was intellectual disability. The young person had a very low IQ, and we were not insinuating that the young person had any other issues on the application. So that is one situation that a MD does not have to sign the physician certificate.
One thing I just wanted to mention here is a lot of times a power of attorney, healthcare power of attorney supported decision-making agreement may be appropriate for our high-functioning autism kids, our ADHD kids with, maybe they got processing speed delays, working memory issues. Maybe their IQ is in the 90, 100 range. They're not intellectually disabled. They don't have a low IQ. But quite honestly, they're not quite there yet. And so, but they do have the capacity to understand what they're signing. That is where I've seen the most appropriate of the power of attorney and the healthcare power of attorney. And this is where families say, hey, little Johnny just isn't there yet. We are hopeful and optimistic that he's going to get there, but he's just not there yet. But he does understand what he's signing. And that is where, sometimes that healthcare power of attorney and supported decision-making agreement will be possibly a better fit than the more restrictive option.
Yeah, absolutely. And the reason that the court does have the alternatives to guardianship is the point that in the old days you were having people put under guardianship, and they really did not need it. All right, next slide, please.
Do you want me to go past the guardianship of the person?
Yeah, if you will, thanks.
Okay.
All right, guardianship of the state. Hopefully you can hear me. Can you hear me, Allison?
Yep, we hear you. It's
Okay.
all good.
All right. So guardianship of the state is usually for elderly people, or if a loved one has an account, which I normally like to have them get rid of. But we won't go through this because a lot of times for our kids turning 18, we just get guardianship of the person. Next slide. We talked about this. Once your child turns 18, he or she's an adult, and you either have to get guardianship or power of attorney and medical power of attorney. What I will say is that if you're lucky enough to still have your parents, mine are gone, be sure that you're named as one of their agents in their power of attorney and medical power of attorney. A lot of times our loved ones will just have each other as their agents. And if one gets dementia and the other has a stroke, then the only thing the kids can do is get guardianship of their parents. So please ask your parents to have you as one of their agents. And what they can do, they can actually have a sign saying that until you become incapacitated, then it won't be effective. Next slide.
I always say, if you're taking notes here, here's where you make a note to have intentional conversations with your parents about this. Don't wait for the crisis to happen, the stroke, or something major happening. And it is strongly our recommendation that you get power of attorney and healthcare power of attorney for your kids that your neurotypical kids that you're sending off to college. If there's an accident, if there's a mental health crisis at college and things like that, it's going to be real important. If you don't have those documents in place, they are over 18 years old and there's a mental health crisis and they haul them out to a mental health facility, they won't even tell you where they took them. So it is a big deal. And you can have it, where it becomes effective immediately or it becomes effective on incapacitation. But a lot of times, I always say the squeaky wheel gets the grease. So we're always thinking about our special needs kids, but the other kids, it's important to don't forget them once they turn 18 as well.
Absolutely. Definitely, if your child's going off to A&M or Texas and has a wreck on the way and they're over the age of 18, then you can't even call the hospital and check on them. So definitely on your college-bound kids, have the power of attorney and medical power of attorney for them. Next slide.
We have one more question. My daughter is nonverbal with multiple disabilities. She's turning 17 this week. When could I start the process for filing for guardianship?
Well, I normally tell parents to give myself or their attorney a call 8 months ahead of time. You have to get an appointment for your physician's certificate. It's not as hard now, but during COVID, that's why I would, tell people to do it 8 months ahead of time. And then as we get close to that 6 months, once we hit the 6 month time frame prior to turning 18, we can file the application. So that's really the time frame between 8 and 6 months. That's when you need to start the process. All right, we talked about the less restrictive alternatives. Durable power, we talked about medical power. HIPAA release, we don't do a lot of those, but they're basically allowing someone to get written and digital medical records on you. The medical power of attorney actually will allow you to talk to the physicians. Able account, that's something that if you don't have a trust, you can do an able account, which will allow you to pay. Alice can go over these, but will allow you to pay for food and lodging in cash, which the special needs trusts do not. Supported decision-making agreement, we're going to talk about that quite a bit. I will say that in Texas, if you have your parent is getting too old to drive and you really don't want to take the keys away from them, then there's a case law that you can call the local DPS, and they will actually give your parent a new driving test without you being named as the villain. So that's one thing I tell parents. It may be kids, it may be easier to do that than take the keys away from their parents. Next slide. We'll skip past this. Next slide. Next slide. All right, supported decision-making agreements. As I mentioned, in 2015, these came about. Next slide. But the main difference between this and the medical power of attorney and power of attorney is that with those documents, you have to have the cognitive ability to understand what you're signing, and they're a fiduciary duty, which means you have a legal responsibility to act on the benefit of your loved one. The supported decision-making agreement is just a confidential agreement or relationship between you and your loved one. Next slide. And the reason behind this is that the only thing that the supported decision-making agreement does, and your loved one doesn't have to have the capacity to understand what he and she is signing. It's the gray area. It's what we actually use it for is that if your child does not have the cognitive ability to sign a power of attorney, a medical power of attorney, and you may not yet have the finances to go for a guardianship, then you can get your loved one to sign a supported decision-making agreement. And that will allow you to, I've got 4 minutes, allow you to get into the meetings to explain to your loved one what's going on. You can never make a decision for them, but you as the parents know how best they understand. So this allows you to get into meetings, the ARGs, or get into a doctor's office and explain to your loved one. Next slide. Letter of intent. Ours is 75 pages. It basically tells you everything about your loved one. My wife does a lot of stuff. I do a lot of stuff for my daughter, but if we were both died in a car accident, whoever takes over as my daughter's guardian can read our letter of intent in about 45 minutes and know everything that my daughter does, from getting up in the morning to her 5 jobs, who's the supervisors, her doctors, and everything. You can buy these forms from attorneys. You can get online and do them, or you can get a 3-ring notebook and put everything in it. But I will suggest, please do this for your loved one, because you're the one that knows more about them and their everyday lives. And whoever you have as their successor guardian, it will be extremely helpful to have this form. Next slide.
We have a form fillable PDF of a letter of intent, so you can email us for that. We'll be happy to share that. And also on our YouTube channel, the Consolidated Planning Group YouTube channel, we have a whole webinar dedicated to a letter of intent and how to kind of set it up and what needs to be on it. So, and you're going to get this slide as well as some of the information that goes into that letter of intent. So I know that we are running out of time. Talk to us about some possible problems that we could run into, Boyd.
Yeah, normal parents set up 529 college accounts. They can be used for cousins or siblings if the loved one that they're not set up for cannot go to college. Also, you can move that into an ABLE account. The UTMA account, again, grandparents set this up in Texas. The money transfers at age 21. If you're getting guardianship, Montgomery County will allow you to get guardianship of the person as long as you transfer that UTMA account prior to age 21. They're transferred into a first party trust, but all the other counties will make you get guardianship of the estate. So I always tell parents is before they do that, let's go ahead and transfer it out.
UGMA and UTMAs are no-nos for our special needs kid because it is an asset that will be counted against them for SSI and Medicaid purposes as well, and we can help with that.
Yep. Also, in your life insurance policies or your retirement funds, be sure to name your child's special needs trust as a beneficiary. Even if you've got typical minor children, they cannot get these. Since we're out of time, I won't go into that, but just keep that in mind, and I'll be glad to talk to you later about that. Next slide.
For sure.
Yep.
So we've got Boyd's contact information and a little picture of his beautiful family and Caitlin right there. Boyd, you went over a lot of information with us today. Before, please don't jump off because Patricia has the survey that she is going to need to put up on the screen. And Patricia, you can feel free to put that up. But Boyd is here. He can help. He can answer your questions. So do reach out to Boyd and kind of talk to him about your situation and kind of what help you need. Our contact information will be in these slides that we're sending out to everybody, and you can visit our YouTube channel for basically there are over 200 topics on our YouTube channel surrounding special needs and special needs planning, and you can peruse those by topic on the step that you're on and listen to the things that are important to you. So that's the Consolidated Planning Group YouTube channel, and you can subscribe to that for free. It has certainly been our pleasure being with you today here, Boyd and Patricia. Thank you very much for having us.
Thank you so much for coming and sharing with us. I'm a special needs parent too, so I was listening the whole time.
Oh, very good.
So glad, so glad. Thank you so much, guys, and we will look forward to chatting with you again soon. We'll have a link to our upcoming webinars, so you can check out those topics and register for those in the future as well. So thanks, everyone. I hope everybody has a great afternoon. Bye now.